I once watched a case settle for $42,000 that the IRS had told the taxpayer would cost them $100,000. Same client, same debt, same documents. The only thing that changed was the room the case was reviewed in. Most people never see that room. I'm Peter Salinger. I spent over 30 years inside the IRS as a revenue officer, a branch chief in the Offer and Compromise Department, and an appeals settlement officer. For a long stretch of that career, I sat on the side of the table that made these decisions. I'm telling you today what I wish more taxpayers understood before they walked in. The IRS Independent Office of Appeals isn't part of the collection division. It isn't part of the audit. It's separate by design. The way Congress set it up, there was supposed to be a second pair of eyes inside the IRS. Someone who could look at a case the first agent got wrong and correct it. When your case lands in appeals, you're no longer arguing with the person who already told you no. You're sitting across from someone whose entire job is to settle, not to collect. Now, this is where I'd see people make their first mistake. They'd walk in thinking appeals was the place to explain how hard things had been. How could they not afford to pay? How the IRS had been unfair. I understood why they thought that way. But that's not what a settlement officer is trained to evaluate. They're looking at two things: hazards of litigation and what would realistically happen if this case went to tax court. If the IRS's position is weak, if a judge might side with the taxpayer, the settlement officer can settle for less, sometimes far less, but the taxpayer has to give them the legal cover to do it. Documents, citations, a clear position. That's what moves the number, not the story. Here's something that surprised the taxpayers I worked with. A settlement officer has more authority than the revenue officer who first denied the case. They can reduce penalties on their own. They can approve a partial payment plan that collects payments already turned down. They can even reverse a denied offer and compromise if the math supports it. The catch, and this matters, is that they won't bend the rules. They'll only bend the outcome, and only if the paperwork in front of them gives them the cover to do it. That's the part most people miss. The same case can get rejected at collections and accepted at appeals. Same facts, same numbers, just a different framing and a different decision maker. Let me walk you through a scenario I saw play out more than once. The IRS rejects an offer in compromise at the collection level. They tell the taxpayer they can pay $100,000 over the remaining statute. The taxpayer files an appeal. In appeals, a fresh review goes through the financials line by line. The settlement officer accepts the medical expenses that the first reviewer had thrown out. A drop in business income that had been ignored gets factored back in. The reasonable collection potential gets recalculated. Final number, $42,000. Same client, same debt, same documents. The difference was the room they got reviewed in. After all these years, the three mistakes I saw most often inside appeals were the same three. The first one was filing late. You usually have 30 days to request an appeal. I watched people miss it by a week and lose their rights entirely. The IRS just kept collecting. The second one was showing up unprepared. Settlement officers had the full case file. They'd read every transcript. They knew the history better than the taxpayer did. Walking in without your own documents puts you behind before the meeting even starts. The third one was arguing the wrong issue. Appeals isn't the place to dispute the tax itself if that window has already closed. It's the place to dispute the collection action, the penalty, or the settlement amount. Get that wrong, and the case dies on procedure, not on the merits. So if you're sitting with a rejection letter in front of you, here's how to actually prepare. First, read that letter carefully and figure out the exact issue you're appealing. Penalty, balance, collection action, they're all handled differently. Second, pull your full IRS transcripts and reconstruct the financial picture. The settlement officer is going to do this. You need to get there first. Third, build your hazards argument. What would a tax court judge see if this case went to litigation? That's the lens appeals uses. Speak their language, and the conversation changes immediately. Appeals is one of the most powerful tools in the IRS system. And after decades of watching it work, I can tell you it's also one of the most underused, but only if you walk in prepared.